We have two guests to talk about that big legal issue right now. Susan Ursel is a lawyer with Green and Schafer, and she's representing the Occupy Toronto protesters. And Chris Schafer is a lawyer and executive director of the Canadian Constitution Foundation. They both join us from Toronto. Welcome.
Thanks for having me.
Hello. Okay, so I'm going to start with you because representing the protesters, what is the chief grievance that the protesters are bringing forward? What is the chief thing that they've now got a stay of execution, so to speak, in Toronto? What's their next legal step that they're going to take?
Right. Well, on Tuesday. Sorry,
go ahead.
Are you talking to me?
Yes, I am. Sorry.
Yeah. Okay, thanks. On Tuesday, we got a stay of the eviction notice that was served on the protesters at the encampment. And it's returnable on Friday to have fuller arguments made about their rights. Now, the issue between the city and the protesters at this point is the protesters have asserted their charter rights to freedom of expression, assembly, conscience, and association. And the city is asserting its property rights to clear the park out. So this is the tension that's going on in the court, and it requires a judge to adjudicate upon it, and that's what's going to happen on Friday.
And David, what's your sense of where this judge will come down? Some have argued that it's not simply that our constitutional rights in the charter may be more important, be given more primacy, but can the city really make a case that there is a pressing health or security objective necessity that requires getting these people out of the park now?
Well, you know, the issue here is the Canadian Constitution Foundation is one of the biggest defenders of freedom of speech, but the big question we have to ask ourselves right now is, does the Occupy movement, through its exercise of freedom of speech, have the right to live and occupy a public space? You know, am I free then on the weekend to take my niece and fly a kite or walk my dog? At what point can a movement occupy public land and indefinitely expropriate that land? The court is going to have to balance these rights, and if we look at a variety of Supreme Court cases, I'm hoping, if you look at one, for example, City of Montreal v. Numbered Quebec Company, and they looked at whether a nightclub could play music loud outside, and that was a protected freedom of speech issue, and the court said, yes, you have that right, but you can't play it after midnight because it's a nuisance. So the court's going to have to do a balancing act here. I hope they come down on the side of recognizing that you can't have an indefinite public expropriation of land by people trying to exercise their freedom of speech, such as the Occupy movement.
Yeah, Susan, how do you respond to that? Because, I mean, if I were to park my car illegally in downtown Toronto and spray paint it with slogans saying, you know, down with the mayor, I could say that's freedom of expression. I shouldn't get a ticket for parking it there, but I get a ticket, I'm pretty sure. How do you square the circle of, you know, we have a right to protest, but at the same time, we're doing something that is an infraction of a bylaw?
Well, this is the central tension in the case, isn't it? And it's funny you should pick the parked car analogy, because the Supreme Court has said even in some cases a parking of a car might even be freedom of expression. So you might have an argument against that parking ticket.
I should use it next time I get a ticket.
Seriously,
thanks.
Exactly. More seriously, I think what we're dealing with here is the birth of a movement that is expressing itself through encampments around the world, and that encampment is an essential part of their expression of their social protest against what's going on in the world and their ideas about how to solve those problems. And that kind of speech, that kind of expression of conscience and political belief and spiritual belief and that kind of freedom of assembly is something that the courts have given extreme deference to and have really considered it to be fundamental, as they should, to the proper operation of a democratic society. So I hear my friend saying that he'd like to see them cleared out, but in fact they represent a significant symbol of what is right in a democracy that functions, which is people collecting in a public place, members of the public, talking about issues of public concern. So when we say we want to clear them out, what we're really saying is we don't want that debate to go on in that public place. And I think that's problematic, and we hope to convince the judge on Friday that clearing out that kind of public debate, even though it's taking a difficult form for many people, is the wrong way to go. It is important that we maintain spaces in our country where the public can have access and can express themselves in as many ways as we can balance. And I think that's one of the other things the courts have looked at, that expression isn't just things that people like to hear.
I'd like to have you weigh in on what Susan's talking about here, specifically, you know, the difference between people gathering in a park for reasons of assembly and free speech, a little bit different than a nightclub playing music after midnight in terms of a hierarchy of needs, of priorities, isn't it?
Well, no, the point I was making is that the
Well,
court
I
there
should think so, yes.
had to balance the issue. They had to say, you know, was this a justifiable limit, putting having to lower the level of the music after midnight? And the court said, yes, you have rights to freedom of speech, so you can play your music. That is an exercise of that freedom, but there's limits to that. So perhaps here, the court will say, look, there's limits. You've been here for a month encamped on public property. You're indefinitely at this point expropriating that land for your own use and forbidding other people from exercising their right to that land. I can't walk my dog, fly a kite, for example. So what they might say is, yes, you have the freedom to assemble, you have a freedom to associate, but we're going to put limits on that. Maybe you can't have tents on the land anymore. Maybe you can only protest until midnight, and after you have to pack up and go home. Or maybe we're going to have a designated free speech zone at Nathan Phillips Square where you can protest and maybe even set up tents. But we're not going to have the situation continue that is expropriating public land for essentially a small Occupy Toronto movement.
Okay, Susan, you saw the evictions upheld in New York. What do you expect the courts will do here?
I think that we have a unique situation in Toronto where a viable community effort is being created in the St. James Park, and I'm hoping that the judge will be looking at what's happening on the ground here in Toronto, and that he will consider the constitutional rights as they operate in Canada. I'm hopeful that he will give a fair hearing, and I know he will, to both sides of the matter, and we are hopeful that he will allow the protesters to remain.
All right, well, that will be the last word. Susan, Ursel, and Chris Schafer, thank you very much for joining us on this debate today on National Affairs.
Thanks for having me.
Thank you very much.